Thank you. Welcome, Saskatoon. Good morning, folks, on this lovely fall morning. Thank you for coming out to this Johnson-Shoyama lecture. We're especially pleased this morning to welcome Professor Nicholas Bala from Queen's University to give us a talk on youth offending in Canada. Professor Bala is Canada's leading academic lawyer on youth justice law. He's a professor of law at Queen's University, where he's been since 1980. He's received many awards, the most prestigious of which is the 2006 Queen's University Prize for Excellence in Research. Each year, Queen's, amongst all of its faculty in the university, selects 2 professors and recognizes their research. And in 2006, they recognized Nick. 2009, the Ontario Law Society did the same with their medal, as did the Ontario Bar Association Family Law section in awarding him their award in that year as well. Nick has written or co-authored over 16 books and 150 book chapters and articles in a variety of legal and interdisciplinary journals. In 2009, he co-authored a book entitled Youth Criminal Justice Law, 2nd edition. He co-authored that with Sanjeev Anand, who you'll know has recently become the Dean of Law at the College of Law at the University of Saskatchewan. Nick is frequently cited by the Supreme Court of Canada in their judgments for his work. He also is frequently invited to international conferences. I know in several weeks he's off to Jamaica to talk to judges and prosecutors in that country about his work. Several weeks ago, Nick appeared before the House of Commons Committee on Justice and Human Rights. He did that in order to address youth justice issues raised by Bill C10, Part 4, which is the omnibus bill, criminal justice bill before the House, Part 4, dealing with youth legislation. Currently, Nick is working on issues related to child witness testimony and to issues involving children and whether they should be interviewed by judges in high conflict divorce situations. Nick is not only an outstanding scholar, he is an outstanding teacher, and I have a personal story to tell. And I'm especially pleased to see John White in the audience. John hired me in 1988, gave me my first job as a law professor in that year. On the Queen's faculty at that time was Nick Bala. I can remember early in September, my wife and I walked down the 2nd floor hall. There weren't many people around. Nick's office door was open. He saw us. He ran out of his office. He welcomed us. He said, where are you going for lunch? And we said, well, we're just going down to the food court. Nick said, no, I'm taking you to the faculty club. So he took us over to the faculty club, which is a beautiful building on the lake in Kingston, Queen's University. And so we're talking, and Nick says, well, now what are you teaching? And I said, well, like all first-year law profs, I'm teaching contracts law. He says, good. And are you all ready for it? And in fact, I'd just been back from Europe. I had one thing ready. I said, well, I'm a little nervous about it. He said, don't worry. And he produced all of his contracts notes from when he taught contracts law. And I can tell you that saved me in my first year teaching. So I owe much of my learning and teaching skills from Nick. I'm very grateful for that. And in return, what I'm going to do for Nick this afternoon is I'm going to take him out on the campaign trail and teach him how to knock on doors. Nick, we're very pleased that you're here with us today. We look forward to your remarks on youth offending in Canada. Welcome.
Thank you so much for those kind words of introduction. It's a great pleasure to be here and talk to you today. And of course, particularly to see my old friend John, who was dean for a number of years at our law school. And what Bob didn't mention is there are 2 great awards at Queen's University. There's the Research Award, and one of the reasons I wanted to actually is I had an old friend who wrote a letter, who was a president of another university, that somehow it got me over to the top. That was Bob's letter that I'm sure was very influential. The other award is the University Award for Teaching Excellence. And when Bob came in 1988, he said, well, I taught him everything he knows about teaching. I'm not sure about that, because by 1991, he won the University Award for Excellence in Teaching at Queen's University, which was a great honor and has rarely been won by anyone in the law school since. So I was fortunate to have Bob as a colleague, and certainly happy to be here for both for this talk and for your political moments. I know this is an area that has huge interest in politics. I'm so impressed that you have in Lakeview, a 90% turnout rate. So obviously there's a lot of interest, a lot of concern about public policy. And I think that's reflected in the kind of discussion that we're going to have today. I'm going to be talking about youth justice. So as Bob says, I'm done some writing and research around youth justice issues, but I'm also going to put it into a public policy context, a bit of a political context. So I'll be going back and forth between criminology, law, and also talking about a little bit in the political context. And so on one view, I'm talking about youth offending, but I'm also going to use this as a bit of an example of what I consider to be really an ideologically driven approach by the present federal government, by the Conservative government, towards youth crime policy. And unfortunately, I think it is a policy and approach that is both economically and socially unwise and will be expensive for reasons that I'm coming to. Obviously, these are not my views alone, and later on I'm going to come and show you some slides. This is very much in the news, even as we speak, about what the views of different governments are about these things. And here we're talking about the fall agenda. I don't know if you can see that cartoon there. Some people say this is the agenda of the fall agenda for the Prime Minister's office, and you can see him, what looks like a cartoon of Harper, driving down the halls of Parliament with a picture of the Queen and ready for the fall session. So this is certainly one of the central issues right now on the government's agenda is the Omnibus Crime Bill, Bill C10. I'm going to be specifically focusing on one part of that. As you may know, there were 9 separate pieces of legislation that were before Parliament in the last session when we had a minority government. And when we had a minority government, there was a lot of discussion and I think attempts to find compromise on various issues. I was a witness actually when the youth justice part was before Parliament. Now that we have a majority government, I think it's pretty clear where we're going. And although, as Bob mentioned, I was a witness at the committee in Ottawa 10 days ago, and I'll talk a little bit about that experience, it's also very clear to me that the hearings are not really very significant there to have, in the sense that the public can hear from people, and I think they're important because it's part of the democratic process. I also think it's important because we're setting down certain markers for the future, and in fact, hopefully saying, the government says this is what its legislation is going to do, let's be clear about that, and let's come back in 4 or 5 years and see if they've actually achieved what it is that they say they're going to achieve. I have very significant doubts about whether we'll have a safer society as a result of the legislation as it goes forward. So I'm going to talk a little bit, first of all, about youth crime in general, what adult perceptions are, and compare that to some of the realities. Talk about why we have a youth justice system, not only in this country, but every country. Then talk about the youth justice regime that we have, relating the regime to youth crime issues, talking a little bit about Saskatchewan. I'd be the first to say I don't know anything about Saskatchewan, or nearly as much as anyone in this room, but I have a little bit of understanding about some of the youth crime issues here, and certainly it's an understandably a major social issue, human issue in Saskatchewan. And then talk about Bill C10 and suggest where we might be going. In some ways, my central theme is that, and this I'm sure happens often in the School of Public Policy, that we have a complex, fairly expensive set of problems to deal with, and people are putting forward relatively simplistic solutions that, at least on paper, look very cheap. There's nothing cheaper in this country than having Ottawa enact a law. You know, if you have youth crime is a problem in Regina, elect somebody and they say, vote for me and I'll go to Ottawa and I'll pass a law and you'll have a safer community. Well, unfortunately, the problems are much more complex. One of the themes here, though, is that youth crime in particular gets a great deal of public and media attention, more so than adult crime. And on a per crime basis, there are people in journalism schools sort of count the number of stories that you have written about youth crime and then compare to the number of youth crime that are committed. Say, well, actually, youth crime gets a distorted representation in the media, over-reporting in the media. And part of it has to do, I think, with the attitude of older people, I include myself in this, towards youth. So here we have a quote about the concern about the decline of youth. Children now love luxury. They have bad manners and contempt for authority. They show disrespect for the elders and love chatter in place of exercise. Children, they are tyrants. They contradict their parents, gobble their food, and tyrannize their teachers. That's a quote from Socrates, not Stephen Harper. Okay, so what it shows is that the sense that things are getting worse, that young people, they are out of control, have a very long social history. And I should say many, of course, are wearing poppies and think about Remembrance Day. One little anecdote about this was during the 1930s, veterans from World War I were saying, young people today, meaning in the 30s, are just so irresponsible. If they ever had to fight a war, they'd never be able to do it. And, it's a reflection of adult perceptions of teenagers as opposed to what was actually going on. One can ask, why do adults, and I think there's, let's say, a very long social history that things are getting worse. And partly it may be amnesia or nostalgia about people's youth, in that, in fact, I think if you think back, honestly, many of you were involved in situations that were, in fact, criminal activities. And in fact, when people go out and do studies of young people, it turns out that 100% of young people, or almost 100%, are engaged in criminal activities. Not serious, violent ones, but they're certainly committing crimes including assault, theft, mischief, damage to property, drinking offenses, driving offenses, and so on. So some adults may not remember what they were doing at the time. I think the other thing is that when we talk about youth crime, many people say, well, in my day, kids didn't go around in gangs and have guns and knives the way they do now. And I think that many of us, or certainly myself, had relatively sheltered childhoods, in the sense that it may be that at our school there were not a lot of kids with guns and knives, but the history of youth violence and youth gangs goes back hundreds of years in this country. And indeed, when you look at things like youth homicide was actually much higher in the 19th and early 20th centuries than it is now, partly, I think, because of better access to firearms. And certainly when you talk about youth gangs, their history goes back well into the 19th and 20th century. It's by no means a recent phenomenon. I think another thing that's very much happening, I mentioned the role of the media. The media has certainly gives this a lot of play. Here we have a quote from the Toronto Star. Quote, this is the headline, actually last Saturday. Justice system coddles youth, and the messages. We're not tough enough with young people. And this is a consistent theme of much of the media. And as I'll talk about, I don't think that that's an accurate representation, but it does sell newspapers. And it plays to, I think, fears that people have about the present and about young people. And indeed, when we ask the question, which is often asked implicitly, is youth crime getting worse? Or do we have more youth crime now than we did whenever everyone in this room was a youth, which may have been 10 years ago, 20 years ago, 40 years ago, whatever? And the answer is that the youth crime does not seem to be getting worse if we look back over a long period of time. Now, one of the difficulties is in terms of real research is it's very hard to actually know what the crime rate was 40 or 50 years ago. The stats are not nearly as good as they are now. I think that, however, on certain measures, and a good measure is probably youth homicide, the youth homicide rate, and I'll actually show you a graph in a while, is not higher today than it was 20 or 30 years ago. However, I think what has happened is young people today do have they are less respectful. I mean, people see that and they sense that. And maybe it's because I'm old, but I think that that's probably true, and there's actually research about that. Young people do tend to push back more verbally in family situations. They're less respectful of adults than they were, and that includes in the court system, but elsewhere as well. They do have more of an attitude. But what I would note is that adults are also less respectful. We have less respect for ministers, for premiers, for members of the clergy, or the way that people dress. You say, well, gee, young people, what are they doing? They're all tattooed, and they have, in my day, if you wanted to make a statement, you had a T-shirt and jeans. Well, you could be Steve Jobs, you could be a multi-billionaire, a business leader dressed like that. So today, if you want to make a statement, you have to go further. And kids have always been making a statement with their dress attire. They just have to go further. I think at least in part, what we see is a reflection of how adults interact with one another. And I'm not saying it's a bad thing necessarily. I mean, we live in a much more egalitarian society than we did 40 or 50 years ago. We also live in one where people are prepared to say what they think more and less deferential. Now, turning to the issue of how should we deal with young people who offend, should we deal with them in a different way than adults? And I think the answer certainly is yes. Almost every society there is distinctive treatment of young people who violate the criminal law, and the question is, how do we treat them differently? It's really, among other things, a reflection of the fact that adolescence in Canada, 12 to 17, is a different stage of life from childhood. Under 12, we say you're not going to be treated in the criminal justice system, or adulthood. And it reflects the fact that adolescence is a distinctive stage of life. And while physical maturing may well end when people, actually 14, 15, they're pretty well physically fully grown. But one of the things that we're discovering now is, and I think intuitively people were aware of this before, the brain continues to develop and is not fully developed by any means when someone is 16, 17, even 18. It's not a coincidence probably that, in fact, historically the beginning of adulthood was 21. And then people sort of said, well, when you're 18, you can go to war and you're fully grown, so why not lower the age to 18? And there's, I think, I'm not advocating raising it. But in fact, if you look at, now that we have brain scans and MRIs and so on, we actually look at the brains of young people, especially, well, men and women, 18, 19, 20, 21, 22, their brains are still growing and changing, and they're not actually adult brains. And that's why those of us who have children, who are 21 or whatever, you say, well, what was that kid thinking? And the answer is his brain was actually not fully formed. And I should say the male brain develops at least 2 years after the female brain. And that's why young people are, I think for many parents, when they look at their children, say, oh, it was so nice when they were little, they were well behaved, they loved us, they maybe got into a little bit of trouble. It's nice when they're adults or they're 25, they're friends and so on. But boy, those teen years, which seem to go on into the early 20s, were really hard. And that's a reflection, middle class, stable families, their problems, and more so in families where they're more significant problems. But young people, because and in some ways they do act like, or at least sound like adults, and they actually have some of the cognitive capacities of adults, but the parts of the brain, the frontal lobe that deals with judgment and planning for the future, is not fully formed at that point, and therefore they make lots of bad decisions about. They engage in high risk activities. They think they're invulnerable. This is, if you look at, and we're going to look at crime, but crime peaks about the age of 18, but so does unsafe sex practices. Starting smoking starts at that time, and so on. There's a lack of foresight and planning, and on the other side, a sense of invulnerability. Oh, other people may have accidents. I'm not going to, because I'm a great driver. And I say, looking at brain development now is it's interesting. So we have actually here, I have a diagram of brain development. You can see that. Obviously, it's a cartoon. But the point is that there's a lot of serious work in being done about adolescent brain development, and I think it has actually been influential in the courts and elsewhere in trying to understand why young people in general do not have the judgment and moral development of adults, and therefore it's inappropriate to treat them in the same way as adults. And so when we think specifically about the issue of offending, in general, all kinds of harmful and self-destructive behavior peak in adolescence, including alcohol and drug abuse, unsafe sex practices. As people move from childhood to adolescence, their peers become much more important. So one of the things about adolescent offenses is they're much more likely to be committed in groups than alone. One of the things I mentioned is almost all adolescents are committing offenses, and that's also a major social issue. If we say in a school, we have zero tolerance. Any young person who commits any offense, they're out of the school, which at some moment some of our schools say. That's a huge problem. I say, well, what percentage of kids are committing offenses? Well, if you find out it's 80 or 90%, you say, we're not going to have many kids in school, so we have to start to make judgments about that. And I should say I have real concerns about the kids who most need to be in school, those who are committing offenses. While I say all young people commit offenses, it is also true that there's a subgroup that will commit more serious offenses, more repeat offenses. With many young people who are, good kids, they commit one offense. They may commit more. If they're not caught, it'll gradually stop. If they are caught and they're arrested and taken home or something, that has a huge end. The parents, carry on and so on. And I should say, I do some work with young offenders in this situation in Kingston. It's a huge family crisis if someone's picked up for shoplifting. But most kids, if they're arrested once and there's a response, they don't reoffend. Like, they get the message very quickly. And there is deterrence, but the deterrence is, I've been arrested. Maybe I was taken to the jail. My parents know. Everybody knows. And it's a crisis that, as I tell young people and their parents in this situation, if this doesn't happen again, your parents will certainly forgive you, but they'll never forget it. But there is a subgroup, and the one that we're probably most focused on in the youth justice system, who are kids who commit more serious offenses, repeat offenses. And by and large, although not completely, these are kids who have all kinds of social challenges. And in particular, many of them would have fetal alcohol syndrome disorders. They may have neurological issues. They often have a history of having been abused or neglected as children. In Saskatchewan, they would be disproportionately Aboriginal. By the way, this presentation will be available on the website, and there are references at the end. There's a very nice study by the British Columbia Representative of Children and Youth, who was, by the way, a judge here, Marianne Turpel, and about youth offending in British Columbia, and she noted that and pointed out that children in British Columbia who are in the child welfare system are more likely to be in the youth justice system to graduate from high school. So it's a very, very serious set of issues with a subpopulation. One of the things I would say about adolescent offending is while adolescents are actually more likely to commit offenses than older people, they're not very good criminals. Often you don't have to be Sherlock Holmes to discover who did it. And in fact, that's one of the things that actually shocks people, in that they can be quite brutal, or extremely brutal and callous, and they'll commit a murder. And when an adult commits a murder, they say, how am I going to cover this up, dispose the body, and so on. An adolescent commits a murder, and they invite their friends over to see the body. Or if they're a little more circumspect, there's this case in Toronto called the Bathtub Girls murder, where these two girls decide to kill their mother. It was a very tragic situation. She was an alcoholic and emotionally abusive. So, of course, how do you, when you want to kill somebody, you say, well, how am I going to do this and not get caught? So, of course, they go on the internet and you find sites that tell you how to commit murder without getting caught. And they actually were very good at it. It turns out drowning someone, by the way, it's the same thing in the canal killings in Kingston. Drowning tends to be a good thing, and so they got her drunk and so on, and well, she didn't take much to get her drunk, unfortunately. They gave her some pills, and they held her head underwater in the bathtub. In fact, and then they sort of, 911, they phoned 911. We found mother drowned in the bathtub, and they come and try to revive her and so on. And they don't realize the EMS doesn't think it's a murder. But while they were committing the murder, they're busy and planning it. They're emailing their friends. During the whole thing, they're texting and emailing their friends as it's going on. Have you killed her yet? No, not yet. Oh, she's coming in. And then they get away with it, and they only tell their few closest friends about what happened, who tell only their few closest friends. And by the end of a year, every kid in that school, there were about 600 kids, knew about the murder, and nobody told. Finally, a new kid comes into the school who, so happens, is related to the dead woman. And of course, here's the story, and then it gets discovered, and they eventually go back and trace her. But they're not very, they tell everybody and so on. So they're often not very good. But they can be extremely brutal. I'm not saying that they don't have a sense of moral development. So what does youth crime look like there? That's a sort of age. It peaks about the age of 18. It's a very strongly age correlated, and this would be true in every single country. It starts and it falls off with age. I should say this table stops at 55. As it so happens, there's a little bit concerned. There's a growing crime wave of the 60 plus as baby boomers are getting to that stage. Now, Most crimes that are committed by young people are non-violent. They're mainly committed by boys. Most of the young people are not apprehended, or if they are, they don't get to court. But we're really socially concerned primarily about the subgroup that are repeat offenders, the subgroup that are committing violent offenses, and recognize that often has a high correlation to various kinds of issues, being brought up in a high crime area by a single mother, having fetal alcohol syndrome, learning disabilities. What this means is these are kids that are going to be hard to change their behavior. And certainly we do talk about and should talk about rehabilitation and reintegration. With young people, there are a couple of points. One is that certainly most young people who are committing offenses, even those who are committing repeat offenses, they have to be caught and apprehended several times. They will tend to outgrow their criminal behavior. And in fact, that graph that I showed you, age is a huge factor. They mature out of it. They've gone to custody 2 or 3 times. They finally get a job. They get married. They tend to settle down. Some of them won't. They'll be career criminals. One of the things that we do know is, and I'm not going to talk about it a great deal at this moment, but there are things that we can do to intervene in the lives of adolescents who are committing offenses that will tend to lessen the likelihood they will reoffend. Rehabilitation, reintegration, education. And it turns out the things that are most effective are the ones that address the problems of a particular child. So you have to do an assessment. Why is this young person committing this offense? Is it related to drug and alcohol abuse? Can you deal with their drug and alcohol problems? Is it because they don't understand the effect of what they're doing and they need to have so-called cognitive behavioral intervention to help them change the way they're thinking about things? Would it help if they heard from victims? So there are things that we can do. Is this related to economic issues, and should they be helped to get a job, and so on? If they have learning disabilities, if we identify the learning disabilities, can we address them? There is no doubt that rehabilitation is more effective with this population than with older offenders. So you're going to have better success with this population. And legitimately as a society, we do put more resources into youth rehabilitation, than we do with adults. One of the things, though, about this is we have to recognize from a policy perspective the limits of intervention and the limits of rehabilitation. Some young people, because of their emotional or mental state or developmental state, are really not ready to change. So one could say, well, they've committed this offense, here's a program that might help them. They're really not prepared to engage. And in fact, the attitude of young people is often a major issue. The other thing is we know that appropriate rehabilitative services can and statistically does reduce the level of reoffending. But we're not very good yet at being able to predict which young people are going to be helped by a particular program. And so, for example, if we send 100 young people into custody and we say all we're going to do is just lock you up and feed you and give you education, at the end you're going to get out, we might find that we have, depending on the custody facility, a 50% recidivism rate. If we say when you're there, we're going to try to work with you around issues around values, behavior, and psychological counseling, try to deal with your drug addiction problems, we can reduce the level of reoffending quite significantly. We can go from 50% to 40% or even 30% depending on the population. So putting resources into rehabilitation has huge value in the sense of if we go from 50% to 30%, that's a very big chunk of kids who are not going to go out and reoffend. And we're going to save over the lives of those people literally millions of dollars that would be spent in corrections, mental health, and so on. So putting resources in rehabilitation is effective, is socially effective, and has been demonstrated to that. But it's not a panacea. It doesn't mean we can get everybody down. And the problem is, from a decision-making point of view, if you're in youth court, we really don't know of those kids that we send. If we put the rehabilitation there, will we reduce reoffending? Yes. Will we eliminate it? No. Do we know who's going to be helped? No, not really. Not in a meaningfully predictive way. So that's one of the huge challenges. And so while I think it's important to talk about rehabilitation and to put resources into it, it's also important to be aware of the limitations of that. So turning now to the legal system, we've had evolution of the legal system in dealing with youth offending. I should say that historically, we actually didn't really treat young people differently, or at least we said either they were too young to commit a crime, but if they were found guilty, they would be treated the same way as adults. And in fact, in Kingston, I've been museum in Kingston Penitentiary, they had children as young as 8 in Kingston Penitentiary. And it was an extremely brutal environment, and obviously they went out and reoffended when they got out. Then we set up the Juvenile Delinquents Act. Looking around the room, a few of you may remember that legislation. And I want to look around the room. I practiced law under that legislation, so it was in effect till 1984. In most provinces, including Saskatchewan, it dealt with children 7 to 16 years of age, so adulthood began at 16 for criminal law purposes. It, in theory, had a welfare-oriented philosophy and focused on the best interest of the child. In reality, it was often punitive and highly discriminatory. And we've now gone back and done a lot of research. And I should say we ignored the rights of adolescents largely at that time. Many of them didn't have lawyers. And one of the terrible things that we can see is, if we look back, is many of the juveniles who were being sent into juvenile detention facilities, correctional facilities at that time, were being abused by staff. I mean, and similar to the issues in residential schools. A place like Mount Cashel, in effect, was one of these facilities in Newfoundland. And so we realized that, we can say, we're treating you for your best interest, you don't need legal rights, and then we send them someplace where they're being abused. There's a huge advantage in giving young people rights. But in 1984, we set up the Young Offenders Act, came into force, and that was a national regime, 12th to 18th birthday, and it's a regime that focused more on legal rights of young people before arrest, and also, though, more a notion of accountability. Then we had, I'm going to talk more about the Youth Criminal Justice Act that came into effect in 2003. It maintained the division, the 12 to 18 years of age. Now, when we're thinking about youth crime, what was going on in the 1990s now, I mentioned that when the Young Offenders Act was enacted in 1983, it had unanimous support of Parliament. The NDP, Liberals, Conservative at that time, 3 parties, supported that legislation. In the 1990s, youth crime became, and youth offending became, I think, in many ways politicized as an issue, and the public started, when they started to ask the public questions, do you have confidence in the Young Offenders Act? People were saying, no, we need a better regime, and in fact, people then were sort of thinking things are worse now than they were in the past, in the 1990s. As I said, it's a common theme, and in most provinces there were demands for getting tough with young offenders. Although, interestingly, this and in other areas, we see a real dichotomy between Quebec and the other provinces. So Quebec still has much more emphasis on rehabilitation, including today, and they kind of like the Young Offenders Act. On the one side, there was a concern that the act wasn't tough enough. There were these public demands, I think, ill-informed. And on the other side, though, Canada actually already at that time had the highest rate of use of courts and custody for young people in the world. And that's different, by the way, than for adults. We're not the highest. If you look, the States is way above, especially now. But we were sending more young people into courts and custody than any other jurisdiction in the world. And often, by the way, for very short periods of time because they weren't very serious offenses. We were sending a lot of nonviolent offenders. Oh, you've committed an offense. It's not very serious, but we're going to send you a message. You're going to jail for 7 days or 14 days or a month or whatever. And the problem with custody, and I think custody clearly does have a role for some young people, in terms of accountability and protection. But custody, first of all, in terms of rehabilitation, is often not as effective as having a young person in a program in the community, in the sense that his or her problems are in the community, in their family, in their schools. And you say, we're going to send you somewhere else for 6 months, and you'll get some help there. The problems are not going to go away where they were, and so working with young people where they have their problems is often more effective. That doesn't mean we don't need a place for custody. The other thing is custody, of course, is very expensive, especially youth custody, and we spend more on youth custody than we do on adult custody. So we have to ask, is this an effective use of resources? The other concern about custody is that if you take a young person who hasn't committed a very serious offense, maybe it's a slightly more serious offense, but you say, we're going to send you into custody. Well, when they get to custody, they're not the toughest kid there. They're going to hang around with other kids who are actually have worse values often, worse, and to some extent, custody facilities tend to be places where, among other things, there's a lot of recruitment for gangs. I mean, that's, if you're concerned about someone being in a gang, once you send them to custody, they say, there are other kids here, I'm going to get beat up unless I become friends with the people in a gang. they join a gang, and then they get out. Well, of course, they got out. Now they've been in custody. They get back to their community. Everybody says, the parents say, don't hang around with that kid. He's a bad kid. So the only kid they can hang around with are other gang members. And they spiral down. So there is a concern about once you send a young person into custody, and there's research about this, of course, that they tend to spiral down. Some of them. So it's not a very effective, often very effective response. So coming back to the political side here, the Young Offenders Act had unanimous support when it was enacted in Parliament. But then we've seen, I think, politicians gradually exploit fears of youth crime. And I think Stephen Harper has certainly engaged in this. Here's the quote from Stephen Harper. The YCJA is an unmitigated failure. That's pretty strong language for the Prime Minister. And then there's this, well, what we need to do is we need to get tough on youth crime, because if we do, we'll have a safer society. And I'll talk a little bit more about this, but there's a large body of research that increasing the severity of sentences does not produce a safer society. And I'll give you some reference and have a little more discussion about that. But talking now about the Youth Criminal Justice Act, it was intended to do three things, and I think it's largely succeeded, at least the first two. It emphasized diversion from the courts and saying for less serious offenses, let's not send kids to court, let's deal with them in the community if we possibly can. And it restricted the use of custody primarily to violent or repeat offenders. And then it had provisions saying, so to deal with the concern of making too much use of courts and custody, let's put restrictions on this. But for the most serious violent offenders, those who are on the front page of the newspapers, let's facilitate getting adult sentences. That legislation was criticized by the Canadian Alliance as being too soft on crime. They wanted deterrence and denunciation added to that act. Now, as I mentioned, one of the features, an important feature of our present youth justice system is an emphasis on what's called extrajudicial measures or alternative measures. And the idea here is dealing with young people outside of the courts whenever possible with community-based programs. And Saskatchewan here, including involving First Nations, has been a real leader in trying to deal with young people outside the court system. These are obviously less serious offenses, but they might be repeat offenses. One of the things about a young person is they may commit an offense once. You say, well, we may have to give them more than one chance in this way. And I think generally this has been quite successful. Here you have sort of a summary graph. I don't know how well you can see that, but this is the line there, and I'll show you a number of graphs. The line sort of towards the right is when the Youth Criminal Justice Act came into effect. And you can see the effect of that act was, the top line is the youth crime rate. It hasn't changed basically at all since the act came into effect. But the line that goes underneath and then drops down, that's the youth charge rate. So that's we're sending fewer young people into court, charging fewer young people than we were. And the bottom line that then sweeps up with the act coming into force is the rate of diversion. We're dealing with more young people informally in the community than we were. And Canada's rate of diversion is still relatively low compared to some other countries, but we see a pretty dramatic change here. So the legislation has clearly had an effect. One of the issues and one of the many controversies about youth crime is do young people have legal rights? And they certainly do. They have all the rights that adults have, and then there are special protections in the Act. And in particular, when they're being questioned by the police, there are special protections to try to ensure they don't make false confessions. And they also have added rights to have legal representation. An adult has the right to retain a lawyer if they can afford it. A young person has a right to have a lawyer paid by the government. Some young people will waive that right, but if the matter's all serious, they'll get a lawyer paid here in Saskatchewan by the Saskatchewan Legal Aid Commission, paid without regard to their own or their parents' means. And that's not uncontroversial, but I think if we're going to have a form of legal justice, and that is appropriate. So the Act has those provisions in there. Another set of provisions deal with pretrial detention. I'm going to talk about this. One of the concerns, pretrial detention, young persons commit an offense, they're arrested, they may be released or they may be detained, and then there'll be a process, they'll plead guilty or have a trial, be found not guilty. There is this stage of pretrial detention or remand, and one of the concerns both before the Act and continuing is that many young people are being placed in pretrial detention. And pretrial detention is a stage where it's particularly difficult or impossible to actually meaningfully rehabilitate, and the young person has not yet been found guilty of an offense. If you're in the correctional system, you can say, well, when we do rehabilitation, we need to plan for it. So if we have someone being sentenced, we're told it's a 6-month sentence. Oh, we know that, Bob Smith is coming here next week. He has these kind of problems. We'll have 6 months to work with him. If you have pretrial detention, there's no planning. I mean, the kids just come in literally off the street, so there's no time to plan. There's no rehabilitative services often, and it's a particularly traumatic part of the process. So there certainly was a hope that the Act would reduce pretrial detention. In fact, it hasn't, but I'll talk about that. The Act, the Youth Criminal Justice Act, really structures and limits judicial discretion here. Sentencing is to be proportionate to the offense, more rehabilitative than for adults, less accountability, but less accountability. One of the things the Act has is it has so-called gateways to custody. So the idea that a young person can only be placed in custody if one of these 4 things have happened. There's been a violent offense, the young person has failed to comply with non-custodial sentence, i.e. probation, or there's been a pattern of finding of guilt or exceptional circumstance. And essentially saying it's violence or some kind of persistent pattern of offending, narrowing down the case, narrowing down the scope for use of custody. One of the controversies, and I'll talk about it now and then come back to it, is deterrence. Deterrence is not mentioned in the Youth Criminal Justice Act. It is for adults, it's in the criminal code, but the Supreme Court has said the silence of the Youth Criminal Justice Act means that general deterrence and specific deterrence, imposing a greater sentence in order to deter someone from committing a further offense, is not to be a factor in sentencing. This doesn't mean that there's no deterrent value to the youth justice system, quite to the contrary. As the court recognized, knowing that you might be caught and being sanctioned in some ways clearly has a deterrent effect. But the emphasis is that having longer sentences does not deter young people from committing offenses. And this goes back to the issue of brain development and the lack of judgment and foresight that young people have. So while if we are increasing the perception of young people that they're likely to be caught, that may affect their behavior. So you're saying, if we're concerned about violence in the schools, putting a police officer in a school may help do that. But saying, if you're caught and sentenced, the sentence is not going to be 6 months, it's going to be a year, that has no effect on young people. I mean, that takes such long-range planning. For most young people, long-range planning means, what am I going to be doing Friday night? I mean, they're not thinking about, and when they're committing offenses, the problem is that they're thinking they're not going to be caught. They feel invulnerable. Now, it's unfortunate they feel that, but that's the reality, and that actually has again to do with their brain development. So there's a huge amount of research that increase in severity of sentences does not affect youth behavior. Another, counterexample is, in the United States, they used to have capital punishment for young people. It had no effect on their whether they commit offenses. They weren't thinking about getting caught. On the other hand, if we include deterrence in legislation, it does affect judicial behavior. It's no longer in the legislation. So here, this is a graph, again, showing the decrease in the rate of use of custody. You can see a dramatic decline there in the use of custody when the Act came into force. There is, however, still a lot of variation across Canada. And I don't know if you can see it there, but this is across Canada. We see provinces, British Columbia and Quebec, which have a real focus on rehabilitation. Both the provinces those two provinces have a particular focus on rehabilitation and arguably have different youth crime problems. Saskatchewan Saskatchewan, Manitoba, Northwest Territories are at the very high end of rates of custody, upset this population standardized basis for young people. And undoubtedly, there are issues in the justice system, there are social issues, there are issues around First Nations populations, there are issues around discrimination and so on. That's a complex story, but it does tell you there's a lot of variation across Canada. The other thing I mentioned is youth custody has certainly gone down, and that's the top solid line. You can see it going down. The bottom line there, the dots that actually get above the solid line, is youth in remand or detention. So that rate has actually gone up since the Act has come into force, and we have more young people entering into pretrial detention than we do entering into custody. So there's a really big issue about what are we going to do about detention. Then one says, well, what's the effect of all this legislation? I mentioned that the Youth Criminal Justice Act does not result in an increase in the rate of youth crime. And here we have a graph about the one that caused probably the most concern, rates of youth homicide. And I should say young people, although they commit a disproportionately large portion of property offenses, they actually commit a relatively small portion of homicides. And there you don't see any pattern at all. And it tends to fluctuate. But the Youth Criminal Justice Act clearly did not result in an increase in levels of youth homicide. So the fact that young people may be less likely to get into custody is not affecting their behavior. And furthermore, that's one graph. Another one that illustrates the same point. This is called the Youth Crime Severity Index. This is a measure that Stats Canada has put forward to look at a number of serious offenses, and including violent offenses. And you see it's flat, if not slightly going down, since the Youth Criminal Justice Act came into effect. So one of the things we've gone through a major national experiment saying we're sending fewer young people into custody, fewer of them into court, and youth crime is not going up, and if anything, maybe slightly going down. And that tells you that sending young people into custody is not a very effective way of responding to them. The Act has provisions around confidentiality. The names of young people generally cannot be identified in the media. That's, of course, controversial with some people in the media. I want to talk for a moment about adult sanctioning. The most serious young offenders can receive an adult sentence, and we changed the way that this was going to be done when the Youth Criminal Justice Act came into force in 2003. And the process that we now have in the Act, they actually say that if you commit, well, let's say, talking about homicide, the maximum sentence for homicide is 10 years. If you're a youth, if it's adult, it's life imprisonment. But for certain very serious offenses, if you're 14 or older, the Act created a presumption that there would be an adult sentence, and particularly murder, attempted murder, manslaughter, aggravated assault, third serious violent offense. There was a presumption that an adult sentence would be imposed. So they were trying to say, the most serious offenders, we want you dealt with in a different way. Interestingly, the Supreme Court, in a case called RVDB, struck down the presumption of adult sentencing. This was, and I should say, in my view, this is the most important juvenile justice decision in the history of this country. It was a charged decision. If it was a legal audience, I'd go into a lot more. But it very significantly said that, yes, we can have adult sentences, but there should not be a presumption for any young person. The onus should always be on the Crown to justify why young people are going to receive an adult sentence. And there she said, this is Justice Bala, writing for the majority of the court. She said there is a presumption of diminished moral blameworthiness or culpability, meaning that there is a presumption that young people are going to be treated differently from adults. I think this is an incredibly important recognition by the Supreme Court. Important not only because they recognize it, but they also constitutionalized it. And so now one of the principles of fundamental justice in Canada is young people will presumptively be treated differently from adults. So a very important statement, and one that has significant practical effect on how the law can be changed. And indeed, what are the implications? Some people this was a highly controversial decision, but it is now part of our constitutional law. And one of the things I think about this decision is that it's restricted the ability of the Conservative government to undertake certain kinds of reforms. And we've said, really, up to the age of 18, there's a presumption that young people will be dealt with differently from adults, and that's very much part of the law and our Constitution now. So, the Omnibus Crime Bill, where has this been going? Bill C10. As I mentioned, there were 9 separate pieces of legislation. One of them dealt with amendments to the Youth Criminal Justice Act. They've now been brought into one piece of legislation. What has the Conservative Party been saying about youth crime? Well, going back to the days of the Canadian Alliance, I mentioned the Canadian Alliance position was deterrence and denunciation should be included in the principles of the Youth Criminal Justice Act. That is not there now. Then you had the statement during the 2006 election, and I should say I follow the Prime Minister's statements about youth crime pretty closely, and he doesn't speak about it too often, but when he does, the kind of rhetoric he uses like this, it's been an unmitigated failure. The law doesn't hold young lawbreakers responsible for the behavior or make them accountable to victims in society. We need to do something about this. Then, at one point, then Justice Minister Vic Taves proposed reducing the minimum age from 12 to 10. And in the 2008 election, part of the Conservative platform was they wanted automatic stiffer sentences for persons 14 or older committed of serious and violent offenses. So there was a fairly strong rhetorical move in this direction. The legislation was introduced again at the end of September, Bill C10, and we've had parliamentary hearings. I'm going to talk about these for a minute. And the hearings has sort of degenerated, I think, a little bit into we have a majority government now, and the opposition tends to want to have people who are experts. Of course, I'm an expert, and of course, being called an expert sounds nice, but you're derided there immediately. Oh, you're just academic knowledge, what do you know? And so I think helpfully they also have frontline professionals. So the last time I was there, they had a youth court judge. Unfortunately, he had to testify in camera. When I say unfortunately, he didn't want to be on CPAC, I understand that. But the frontline professionals and the experts, or so-called experts, were saying very similar things. And on the other side, they say, well, let's bring in some people who really know about youth justice. Let's bring in some victims. So the hearings sort of degenerate. Here's one first day of hearings. I wasn't there. I was there a week later. I'll talk about that in a moment. But here you have, on the one hand, they have a lawyer and criminologist, Eugene Oscapel. He's actually a Queen's Law grad, criminologist from University of Toronto. And the Conservative MPs start off by saying, well, you people are here as advocates for criminals. And I don't think that's a very fair, accurate presentation of what people were saying. They were advocating for better criminal justice policy. And the comment is, well, you people are just too far removed from real life. On the other side, I think Professor Dube, who I have a lot of respect for, kind of got into rhetorical, we call this a cruel and dishonest joke on the part of Parliament. So he wasn't pulling his punches either. Happily, I think in the young offenders area, the law is a little more nuanced than in some of the criminal areas. I'm not going to talk about the criminal part of it, or just I'll say a word. As you may know, for example, they're talking about mandatory 6 months jail sentences for people who have possession of a relatively small amount of marijuana for the purpose of trafficking. We don't have that in the youth justice part. I think they're a little more nuanced here. Certainly, on the whole, it is a more punitive legislation we presently have. They want to add denunciation and specific deterrence to the Act. They are going to allow for publication of names of young people who have committed any violent offense. And violent offense is very broadly defined. Any violent offense. You can say, look, maybe we should know about young people who are committing murder or even armed robbery or something, but should we all know about any young person who's pushed another kid in the schoolyard? It's very broad. And they want to facilitate more pretrial detention. So I went there, as Bob mentioned in the introduction, I was there about the beginning of last week, actually. And again, it's sort of an interesting process. I have a brief that would be made available to you if you want, talking about the specific provisions of the Act, talking about in general, somewhat similar to what we're doing here, but more detailed in terms of actually looking at the legislation. There were a couple of people who were professionals who work with young people from a very different perspective, having a similar kind of message. And then beside me, there was a woman who I'd never met. It's Lynn Lacasse. And her, you may know this was originally called Sebastians Law. She had a 19-year-old son who was murdered by a young offender. And it was actually a brutal crime, as these often are. And she was understandably extremely distressed. And there were a number of young people involved. She said, she says, and she made a very moving statement about the effect that the crime has had on her life and her husband and so on. And the MP started saying, well, and that she just made the statement, and then they would read her parts of the Act. If we enacted this, would that be good? Yes. If we enacted this, would this be good? Yes. But she had nothing substantial. And I was sitting beside her, and I wasn't going to cross-examine her or whatever. But, it was a tragic case, but in fact, the principal offender in that case, who was 17, received a life. He was treated. He got an adult sentence and received a life sentence. And the youth justice system didn't fail her. Maybe society failed her son by why do we live where there's violence going on. But it's not like if we had a tougher youth justice system, it would make a difference. He had, that person who killed her son is receiving a life sentence. In our society, we can't do any more. And to put her, and I don't mind if, and I understand why we have to have respect for victims. I would say to the government, if you want to talk to victims, why don't you listen to them on the gun registry? You listen to victims when you want and put them forward. Oh, they know much more than these so-called experts or the frontline professionals. But if you don't like talking about the gun registry, we're not going to hear from them. I think this is one of my hobby horses. Anyway, having said that, I think Bill C10 is problematic. It's actually could have been much worse. So a lot of the historical things that the Conservatives were talking about, like reducing the minimum age or mandatory minimum sentences, are actually not there. So I view Bill C10 in terms of youth justice as regressive, as an unfortunate step, but it's not as bad as it could have been. And one of the questions is, to me, are the Tories just, as a Conservative government, just sort of shifting towards the center and being less punitive? Are they actually listening to people? Are they worried about the issues about the expense of implementing this kind of bill? Certainly, and you've probably been following this in the media in the last few days, we are seeing a national split here. Ontario and Quebec the provincial governments are opposed to this legislation, or more accurately, they're opposed to the cost that will be imposed on the provinces. And although there are federal costs in changing the criminal law, particularly in the youth justice area, all the costs are provincial. It's the provincial government that pays all the costs of youth corrections, unlike adult corrections. So some of the provinces are opposed to this. Saskatchewan, perhaps not surprisingly, has not taken a position on this at this moment, but Alberta and Manitoba have said, oh, this is okay. Other provinces are against it. I think that this legislation certainly will have an effect, but we're also going to see pushback, and we're seeing it from the provinces now, because this legislation continues to allow some discretion and to judges and police officers and probation officers. Unlike with the adult parts of Bill C10, where there are mandatory minimums and they're telling judges what to do, here they're pushing, but they're not making mandatory any changes in the law. They're making changes in the statements in principle, but judges will continue to have discretion. And I suspect that in this area, on the one side, we will not see as dramatic changes we're going to see in the adult system. The other thing we're going to see, though, is a lot of variation, more variation between provinces. So the attitude of provincial governments, of youth court judges, are going to be continue to be very significant. Finally, where do I think that we should be going? I think the Youth Criminal Justice Act has been a success in its terms. We have not eliminated youth crime. No society ever has. But we have a system that has less use of courts, less use of custody, and we've not had an increase in youth crime. So we actually, this is one of the few situations where we can say we can see a piece of legislation, really significant change, actually saving money, no negative effects. So why are we changing it? I don't think that toughening the Youth Criminal Justice Act is going to increase community safety. I think that there certainly are things that we could see that I'd like to see in terms of change in the youth justice system, and indeed in my brief, some parts of Bill C10 I think are desirable. Certainly more support for victims would be an important part of it. Having adequate resources, I think in Saskatchewan as elsewhere, many of the community-based programs are not adequately resourced. Many of the issues are provincial, however, and many of the concerns that people have about the youth justice system, for example, delay. Delay is a major issue in the justice system. It's a provincial responsibility. I think that if we want to live in a safer society, I should say not only a safer society, but also one that ultimately is more competitive in a world, in a global economy, we have to have our young people better educated, better trained. And I work here at a university at the top end, so we'd say, what are we doing for universities? That's very important. But it's also, what are we going to do for the kids who are failing out of school? and who are not graduating from high school and have learning disabilities and FASD, and who might be drifting towards crime. That's also a population that we have to put a lot of resources into. And if we do, we'll have not only a safer society, but I think a more productive society. It's also one of the challenges here is when I say, oh, let's invest in children and young people, which people sort of rhetorically talk about. They probably say, well, if we invest in that today, when's the payoff? Is the payoff before the next election? No, the payoff is going to be 10, 15, 20 years down the line. And so we have to get our politicians thinking about this in a long-term way. Just as we don't build our roads and say, well, let's have a road that only lasts 4 years. So we're going to build this with concrete. It's got to last 50 years. So I think we have to think about how to better educate and support young people, and there are a whole range of social programs. But I've gone on long enough in terms of the presentation here. My hour's up, so I'd like to open it up for questions or comments. Thank you for your attention.